We talked about some of the mistakes, and one of the mistakes involves the way retirement plan accounts work or are dealt with. When I refer to retirement plan accounts, I'm talking about 401k plans and IRAs and 403b plans and similar plans that are funded with pre-tax dollars. That means when the money goes into the retirement account, you're not subjected to income tax on that money. That's because you're entitled to a tax deduction as funds go into the account. But when you withdraw from the retirement account, what you withdraw is included in your taxable income and is subject to income tax at that time. These retirement accounts are meant for your retirement, so if you withdraw from them too early, that means before you're age 59 and a half, you must pay a penalty. Not only must you pay an income tax on the early withdrawal, but you must also pay a penalty on the early withdrawal unless the withdrawal qualifies for certain exceptions. One of those exceptions is the death benefit. Also, since the retirement account funds are intended for retirement, there are rules that say that you must start withdrawing from the retirement account around the time of retirement. You can't just keep your money in that retirement account indefinitely and have it earning income in a tax-favored, tax-deferred environment. There are minimum required distribution rules. The current rule is that after you're age 70 and a half, you must start withdrawing from those accounts. If you don't follow the rules, a penalty is imposed. As this update is being prepared in June 2019, Congress is poised to enact changes to the minimum required distribution rules. The House version will change the age when minimum required distributions must start to age 72, and the Senate version will change that age to 75. Be on the lookout for the final version. The funds in the retirement accounts grow on a tax-free, compounding basis, so every year you add to the account on a tax-free basis, and, in addition, income and appreciation occur in the account tax-free. As a result, by the time you retire, maybe after 30 years or so of doing that, the balances in the account can grow and become very large. I've just finished talking about required minimum distributions and how, once the owner is 70 and a half, the owner must start withdrawing funds. When the owner dies and the beneficiaries are entitled to the balance in the account, the beneficiaries are also subject to minimum required distribution rules and must start taking distributions before the end of the year after the owner's death, unless the beneficiary is the owner's spouse. If the owner's spouse is the beneficiary, the spouse may roll over the full account balance and make that account her own without paying tax, as long as the funds remain in the account or in the rollover account. In that case, the spouse can wait until she's age 70 and a half, or something like 72 or 75 when the new law is enacted, before she must start withdrawing from that account. I want to show you an example of some of the problems these types of accounts can create. Here's an example of a client whose estate is more than the estate tax exemption that's available at his death, whatever that exemption happens to be at the time. Assume that all his assets are illiquid, perhaps all in real estate and in a business with partners. In 2016, his IRA had a value of $1,445,000, and it grows to $2,355,000 when he dies in 2026. The total estate tax would depend on the state in which the client resides, but let's assume that the state estate tax and the federal estate tax will be around $609,000. The question is how that $609,000 in taxes is going to be paid. Remember, we've assumed that this client's non-IRA assets are illiquid, that they cannot easily be converted to cash. There may be a temptation to go in and withdraw that $609,000 from the IRA to pay the estate tax, but keep in mind that any withdrawal from the IRA will be subject to an income tax, so this is the unfortunate result. Here you see that there's a withdrawal made of $609,000 to pay the estate tax, but now there's an income tax on that withdrawal. The income tax is approximately $209,000. So the beneficiary is sitting there, scratching his head and says, how am I going to come up with that $209,000 to pay the income tax? There's only one source for it, so he goes in and withdraws another $209,000 from the IRA and creates a new income tax obligation of $72,000. So he goes in and withdraws another $72,000 to pay the income tax, and now he has a new income tax of $25,000. So you can see what's happening. Every time he makes a withdrawal to pay the income tax, he has a new income tax to pay. So by the time it's over, not only has he had to pay the $609,000 estate tax, on top of that, he has to pay $319,000 in income tax, a total tax bill of $928,000. Part of estate planning is to try to avoid that unfortunate result and to protect the IRA from the estate tax burden. One way to do that, and there are many ways, for example, the provisions of your will can direct what assets bear the burden of the tax, so typically our wills will direct the burden away from the IRAs. Here's something else that can be done for a client with a cash-poor estate. For example, maybe the client has a large IRA and real estate investments. The question for them is, where is the cash going to come from to pay the estate tax? As we've said before, real estate isn't very liquid, and we saw the problems that you get into when you try to use the IRA as a source of paying estate taxes. So lots of times, to protect the IRA, the client will consider purchasing life insurance, and the life insurance is purchased in a way so that it will not generate an estate tax. Remember what I previously said about life insurance. If you're the insured and you're the owner, then the life insurance death benefit is included in your estate when you pass away. But if you're not the owner, it won't be included in your estate. So often the solution is to acquire life insurance, but when you do so, to make certain that the insured is not the owner. Instead, a trust called an irrevocable life insurance trust can be the owner. That's a very common plan. In that case, the trust owns the life insurance policy and receives the death benefit, and then the death benefit can be used to make a loan to the estate to pay the estate tax. In the next segment, we'll talk about income tax issues related to retirement plan benefits.